Right now, the very foundation of land ownership in British Columbia is being tested. For the first time in Canadian history, a court has recognized Indigenous title over land that includes part of a modern city. Land people have bought, sold, and built homes on for generations. That city is Richmond, and only months after that ruling, another nation filed one of the largest land claims in provincial history, stretching across Kamloops, Sun Peaks, and over 1 million hectares of land that includes private homes, city land, and major communities. Together, these two cases are shaking the core of what it means to own property in our province. This isn't fear-mongering, it's the new legal reality that could change the way ownership, value, and rights work across British Columbia. I'm Shahrad Sardari, a realtor here in Metro Vancouver, and in this video, we're breaking down the two Indigenous land title cases that are changing the meaning of property ownership in BC. Starting with the historic Richmond court ruling, then the massive land claim in Kamloops and Sun Peaks, and finally, what this means for home ownership across our province. Earlier this year, the BC Supreme Court ruled that the Cowichan tribes and related nations hold Aboriginal title over sections of land in Richmond and the Fraser River Delta. That includes areas near the Vancouver International Airport, portions of Lulu Island, and even parts that are already registered as private property. This ruling made legal history. It's the first time a Canadian court has recognized Indigenous title over lands that have already been developed and are privately owned. Until now, fee simple ownership, the system that defines how we own homes, was considered final. Once your name was registered on title, that was it. But that decision shattered that certainty. The court ruled that Indigenous title can still exist underneath the land title system. That means even though your home is legally registered to you, another legal title could also exist below it, one belonging to the Indigenous nations whom claim predates Canada itself. That changes everything. The Land Title Office no longer guarantees absolute ownership the way most people assumed till now. It means the property you own, pay taxes on, and maintain may one day be subject to a negotiation or agreement that you never expected to be a part of. The province has appealed the ruling, saying it must balance reconciliation with protecting private property rights. But until that appeal is decided, this precedent stands, and it raises one of the most important questions BC owners have ever faced. If a court can recognize Aboriginal title over parts of Richmond, what's stopping the same from happening anywhere else? To understand why these cases are happening right now, you need to understand something very unique about British Columbia. Unlike most of Canada, the majority of land in BC is unceded. That means it was never formally surrendered, sold, or transferred through treaties between Indigenous nations and the Crown. In provinces like Ontario, Alberta, or Manitoba, most land was bought under treaty that outlined how land would be shared. But BC is different. Outside of a few small regions of Vancouver Island and in the northeast, treaties were never signed. For over 150 years, the government simply acted as if the land was theirs to sell and develop, while Indigenous nations maintained that it never was. For decades, that tension was ignored. But court decisions over the last 30 years, and now these latest rulings, are forcing BC to face that unresolved history head-on. These land title claims are not random. They're the direct result of a legal system finally catching up to the reality that much of BC's lands was never formally transferred, and that's why these cases are now appearing in cities, suburbs, and growing communities, not just remote regions. For now, no one is losing their property. Your title remains valid, and you can still buy, sell, or refinance your home. But the idea that land ownership in BC is completely untouchable is no longer guaranteed. If the Richmond precedent holds, Aboriginal title could legally coexist with private ownership. That means private owners could face new layers of regulation, shared authority, or even compensation requirements for land that's been privately held for generations. For homeowners, the uncertainty is what makes this serious. Imagine discovering that the land under your home, the land you thought you fully owned, now has another legally recognized title attached to it. No one can tell you exactly what that will mean just yet. Will there be new taxes, restrictions, negotiations? No one knows, and that uncertainty alone is what makes this moment so historic and unsettling. Real estate is built on confidence. People buy homes because they believe their investment is safe. If that confidence is shaken, even slightly, it affects the entire housing market. Not just for investors, but for families, first-time buyers, and retirees who depend on their property as their biggest asset. This is why what's happening in Richmond matters far beyond its borders. If Indigenous title can coexist beneath private land there, it could happen anywhere in British Columbia. Only months after the Richmond ruling, another Indigenous nation took it even further. The nation filed an Aboriginal title claim covering roughly 1.25 million hectares of land, an area larger than Metro Vancouver, Abbotsford, and the Fraser Valley all combined. This claim includes the entire city of Kamloops, the Sun Peaks resort area, and huge parts of the surrounding Thompson River Valley. What makes this case different is its scale. It's not focused on empty or crown land. It includes developed neighborhoods, private homes, commercial areas, and entire communities. If recognized, it would be one of the largest Indigenous title rulings in Canadian history. The nation argues that the land was never surrendered or sold, and that they've continuously occupied and cared for it for generations. They've also raised cultural and environmental concerns about mining, tourism, and urban growth impacting their traditional lands and waterways. For homeowners in Kamloops and Sun Peaks, this claim created confusion and anxiety. Many people had no idea their property was part of an active legal filing until it was reported in the news. And because Aboriginal title cases can take years or even decades to settle, that uncertainty could last for a long time. If the courts validate this claim, it would set a precedent that extends far beyond the interior. It could mean that large parts of BC, including developed urban lands, could eventually be subject to the same kind of overlapping ownership. That's why these two cases together are so significant. They aren't isolated, they're connected by the same root cause: BC's unceded land. When you look at both of these cases, Richmond and Kamloops, you can see two sides of the same coin. On one hand, this could lead to more legal uncertainty, slower transactions, and pressure on property values in areas affected by these claims. The very idea of clear title, something that BC's real estate market depends on, could become harder to define. That uncertainty could ripple through lending, insurance, and long-term investment confidence. But on the other hand, this process could also bring long overdue clarity. For the first time, BC is being forced to address who truly owns what and to build legal frameworks that finally reflect the province's history. Once those frameworks are established, it could restore stability, because everyone will finally know the rules properly. So yes, there's a risk in the short term. Markets hate uncertainty, but there's also potential for a future where issues are finally settled, where both Indigenous and private ownership have legal clarity instead of decades of unresolved conflict. Right now, we're stuck in the middle, and that's why this moment feels so uneasy. It's a province in transition, and no one yet knows where it will land. The Richmond case is now being appealed, and it could take several years before a final ruling is made. If it's upheld, that decision could shape the entire future of property ownership in our province. The Kamloops and Sun Peaks claim is still in its early stages, but it's already expanding the conversation beyond the lower mainland and into the interior. As these cases move forward, the provincial government will be under pressure to create new legislation that defines how Indigenous and private ownership interact side by side. That could mean financial compensation systems, shared governance models, or clearer rules about how title and Aboriginal ownerships can all coexist. But none of this will happen overnight, and while these legal processes unfold, homeowners are left in limbo, unsure what these rules mean for their property value, their security, and their future. That uncertainty is what makes this moment so important. For most British Columbians, real estate isn't just an investment, it's their life savings. When the foundation of ownership shifts, everything tied to it does as well. These two cases represent a defining moment for British Columbia. They're not about taking land away from anyone, they're about reconciling what was never legally resolved. For Indigenous nations, these rulings bring long-awaited recognition and the chance to have their rights acknowledged in law. For homeowners, on the other hand, it's a reminder that what we thought was permanent may not be an absolute, as we believed. And for the province as a whole, this is a test on whether BC can balance fairness, history, and stability all at once. This is bigger than real estate. It's about trust, certainty, and what it truly means to own land in a place built on unceded territory. The next few years will define whether BC finds that balance or falls deeper into uncertainty.